Good afternoon and welcome. My name is John Lott, and I'm an advisor for infrastructure and climate engagement in the Department of Labor's Office of Public Engagement. Thank you all for joining the department for this webinar on the labor standards provisions contained within the Inflation Reduction Act. To kick off today's webinar, you'll hear from Jessica Lumen, the Principal Deputy Administrator of the Wage and Hour Division, and Manny Lamar, Senior Advisor from the Employment and Training Administration, who will share more about the historic labor provisions contained in the IRA and how complying with those provisions will create good jobs that fuel our clean energy transition. Following their remarks, representatives from Wage and Hour Division and the Employment and Training Administration will share a presentation on the IRA's prevailing wage and apprenticeship requirements, as well as an introduction on how to comply. We will then answer some of your questions. Beyond today's presentation, we want to point everyone towards a few resources that exist on our website, which is located at dol.gov/general/inflation-reduction-act-tax-credit. And don't worry, we will also put that in the chat, where you will find links to prevailing wage and apprenticeship specific resources, answers to many of your questions, and a link to Treasury's published guidance. We have developed dozens of FAQs and will continue to add and update our FAQ pages in real time. And additionally, today's webinar is being recorded and will be available on our website for future use. Lastly, we just wanted to take a moment to thank our team for working so hard during the holidays to stand up these resources, and we want to thank all of you for your interest and for joining us today. We encourage you to take advantage of these incentives and opportunities, and we are committed to offering our expertise and experience with these requirements to help you implement these standards. And with that, I'll now turn things over to Jessica Lumen from the Wage and Hour Division.
Thank you so much, John. I am Jessica Lumen. I'm the Principal Deputy Administrator here at the Wage and Hour Division. As many of you know, Wage and Hour is responsible for enforcing some of the nation's most comprehensive federal worker protection laws, including protections related to minimum wage, overtime, child labor, family medical leave, and the Davis-Bacon prevailing wages for government-funded construction contracts. Really want to thank all of you for joining us today. We really hope that this is a valuable resource. As you know, on August 16th, 2022, the President signed the Inflation Reduction Act into law. The Inflation Reduction Act is by far our nation's largest investment in clean energy solutions to date. And by pairing climate investment with the creation of good jobs, the Inflation Reduction Act's unparalleled investment to fight the climate crisis will help improve job quality in clean energy industries and create incentives to expand the workforce training pathways into these important jobs. Critical to providing good-paying jobs, the Inflation Reduction Act offers enhanced tax benefits to taxpayers for a range of clean energy projects that ensure that prevailing wages are paid to workers performing work on these projects and that registered apprentices are utilized on such projects. Under the Inflation Reduction Act, the prevailing wage and apprenticeship requirements generally apply to facilities where the construction begins after January 29th, 2023. We at the Wage and Hour Division recognize that the Inflation Reduction Act's historic commitment to clean energy infrastructure means that some of you may be encountering prevailing wages or apprenticeship for the first time, and we really want to provide the resources today and an ongoing basis to help make sure that any taxpayers and contractors that want to benefit from these increased tax benefits understand how to comply with the IRA's labor standards provisions. So we will continue to engage with our partner at the Department of Treasury, who have put out the guidance around the implementation of the Inflation Reduction Act's labor standards provisions, and we want to serve as a resource for all of you. I'm grateful to be accompanied here today with some of our wonderful staff from the Wage and Hour Division, who will be providing a presentation a little bit later to walk you through some of the information that may be helpful to you as you are thinking about implementing these tax benefit provisions. So thank you again so much for being here. And I'm going to turn it over to my colleague, Manny Lamar, who is with our Employment and Training Administration. Manny?
Thank you, Jessica. You touch upon so many critical points, and it's really been great working with Wage and Hour, Treasury, and leaders across the administration to really make this happen. You mentioned how the Inflation Reduction Act is by far our nation's largest investments in clean energy solutions to date. And really, to put that in context, of the Inflation Reduction Act's $369 billion dollars of investment in addressing climate change, $270 billion will be delivered through tax incentives, putting Treasury and the Internal Revenue Service at the forefront of implementation. At the Employment and Training Administration, we see this as a tremendous opportunity for individuals to really receive the training in these critical industries through registered apprenticeships, which is a proven strategy to develop a skilled and diverse workforce. And this is why the administration and the Department of Labor has invested about $300 million in apprenticeships the past few years and has been investing in apprenticeships and been making significant investments to modernize the apprenticeship system through new tools and resources such as the Standards Builder, the Partner Finder, and additional strategic approaches in our outreach. Now, you'll hear more later from our team on the apprenticeship requirements, but I think it's really important to highlight how we are working to meet the moment. We are continuing to work closely together and have worked to develop and leverage resources to meet the moment, meeting regularly and developing procedures to support implementation. It's a heavy lift, but I'm extremely confident in our ability. We also encourage you to reach out and check out our online resources for additional guidance and information. Again, thank you so much for joining us today. I will pass things back over to John and get us started on some additional important information. Thank you.
Thank you so much, Manny. Before I turn things over to my colleagues, I would like to provide a quick reminder of the tax credits the IRA's labor standards apply to and a timeline of when Treasury's guidance takes effect. For many of the Inflation Reduction Act's incentives, taxpayers will need to meet prevailing wage and apprenticeship requirements to receive increased incentive amounts. On the screen, you see a list of tax credits that the IRA's prevailing wage and apprenticeship requirements apply to. This list can also be found on our website. By statute, the prevailing wage and apprenticeship requirements generally apply to qualifying facilities where construction begins 60 days or more after Treasury and the IRS published guidance on those requirements. On November 30th, 2022, Treasury and the IRS published the guidance on the Inflation Reduction Act's prevailing wage and apprenticeship requirements. The publication of this guidance triggered the 60-day period, meaning that in order to receive increased incentives, taxpayers must meet the prevailing wage and apprenticeship requirements for facilities where construction begins on or after January 29th, 2023. And now I would like to turn things over to Natalie Collins and Megan Vesper from the Wage and Hour Division to walk us through the Inflation Reduction Act's prevailing wage provisions.
Thanks, John. And I just want to echo everyone's thanks to all of you for being here. We are really excited to start walking you through some of these requirements. The first portion of today's session is going to deal with those prevailing wage requirements and drill down into those before we turn it back over to the Office of Apprenticeship to tell us more about the apprenticeship requirements. And then in the remaining time, we'll be answering as many questions as we have time for about both prevailing wage and apprenticeship requirements. So just to give you kind of a preview of the coming attractions for the prevailing wage portion of the seminar, we're going to start off discussing the language of the Inflation Reduction Act provisions itself and how that language establishes the requirements. And then we're going to explain what a prevailing wage rate is and how you find the prevailing wage rates that apply to the construction of your particular facility and where they're located on wage determinations. We'll discuss how to read wage determinations, all the good information you can find on those wage determinations to make sure that you're applying them correctly to your facility. And in the unlikely but possible circumstance that an applicable wage determination does not include every prevailing wage rate that you need, we will review how to obtain additional labor classifications and rates. And finally, although we hope we'll be able to answer as many of your questions as possible today, in case you do have more questions later, we'll also be going to share some additional resources for getting further guidance. So we can move right into the next part of the presentation. So the text of the Inflation Reduction Act and the subsequent guidance published by the Treasury Department, as John mentioned, do lay out the prevailing wage requirements that must be met in order for a taxpayer to successfully claim an enhanced tax benefit. The language for the prevailing wage provisions is is very similar for all of the various tax benefits. So this is one example of that language. And it has some really key components to emphasize. So for the prevailing wage requirements, language says that the taxpayer shall ensure that any laborers or mechanics employed by the taxpayer or any contractor or subcontractor in construction, alteration, or repair of the facility shall be paid wages not less than the prevailing rates for construction, alteration, or repair of a similar character in that locality where the facility is located, as determined by the Secretary of Labor. So that means that to avail yourself of those increased tax benefits on a qualified facility, the taxpayer has to ensure that all laborers and mechanics that are performing construction are paid at least those Davis-Bacon prevailing wage rates determined by the Secretary of Labor. And it also flags that those prevailing wage rates are dependent on where that project is located and, what rates are paid on similar construction of similar facilities in that area. If we could go to the next slide. Thank you, Megan. Now, that language does establish that taxpayers have to ensure that the laborers and mechanics are paid at least those applicable prevailing wage rates. There is a second prong to that requirement. In addition to making sure that the laborers and mechanics are paid the rates, the taxpayers do have to be able to demonstrate those rates were paid if there are later inquiries. So that does mean that taxpayers are going to have to ensure that records are made and maintained, and those records are sufficient to demonstrate that the laborers and mechanics were paid at least those prevailing wage rates for the type of work performed. So the income tax regulations, which provide that any person subject to income tax has to keep records sufficient to establish the amount of any credit or deduction claimed, come into play here, because to be able to establish, the amount of tax benefit that a taxpayer is entitled to under the Inflation Reduction Act, they're going to have to be able to show that for each hour those laborers and mechanics worked on that construction, alteration, or repair of that facility, that they did receive those applicable prevailing wage rates. A little bit later in our presentation, I think we're going to be going into some examples of what those records might look like, but we did just want to emphasize at this point in the presentation that it is important that the taxpayer not only makes and maintains those records for their own laborers and mechanics, but also ensures that any contractors or subcontractors that work on their facility also make and maintain those records. Next slide, please. So we keep talking about these laborers and mechanics who have to receive those prevailing wage rates. Who are they? Who are these laborers and mechanics? When we talk about laborers and mechanics, you've got the definition there. We're talking about those workers who perform primarily manual or physical work in trades or occupations. So workers such as electricians, the iron workers, equipment operators, all of those examples you see on screen or more. So these are the people who are out there working with their hands. They're out there using the tools and equipment of a trade. These are the people that are working on site, actually making that construction magic happen. But there are some important workers involved in the construction of a facility who are not included within this definition of laborers and mechanics, which, if anyone is curious, that definition can be found at 29 CFR 5.2M. So workers whose duties are primarily administrative, executive, or clerical, as opposed to those manual or physical duties, are not considered to be laborers and mechanics. So timekeepers, people who are out there making those important records of hours worked and payroll to meet the IRA prevailing wage provisions, very important, but not laborers and mechanics. Inspectors who make sure that work is being performed to code or that safety requirements are being met, even architects or engineers who make the designs and blueprints and make sure that everything is being constructed in accordance with those designs, are generally not considered laborers and mechanics. Similarly, workers who are employed in what are called bona fide executive, administrative, or professional capacities, and that is a definition that is specific to 29 CFR Part 541, are also not laborers or mechanics. So those are going to be workers who have those executive, administrative, or professional tasks as their primary duty, and in most instances, they also have to receive at least a certain minimum guaranteed salary as set forth in the regulations. There is one additional important point about laborers and mechanics that we do want to emphasize here. Laborers and mechanics do not have to be the employees of the taxpayer, contractor, or subcontractor. The Inflation Reduction Act prevailing wage provisions do apply to any laborer and mechanic who performs work on the construction of that facility, even if they're independent contractors who receive a 1099. If they perform that manual physical labor, if they perform that construction work, regardless of their employment status, they are entitled to those prevailing wage rates. Next slide, please, Megan. All right, so now that we know who gets the prevailing wage rates, let's drill a little bit more down into what we mean when we say a prevailing wage rate. So prevailing wage rate, you have this definition here, is the rate that's listed for a particular classification of labor or mechanic for the type of construction and geographic area where the work is being performed as determined by the Secretary of Labor. So when we say classification of labor or mechanic, in our previous slide, we gave some examples. We talked about electricians and iron workers, equipment operators, and so on. Those are examples of different classifications of laborers and mechanics, right? All the different types of work that need to be done on a construction site and the workers who do that work. Each classification is going to have its own prevailing wage rate that is the minimum rate that laborers and mechanics in that classification need to be paid. Again, emphasizing that the prevailing wage rate is the minimum. It's your basement. It is always possible for taxpayers, contractors, and subcontractors to pay more. Next slide, please. So, breaking that prevailing wage rate down a little bit further, obviously, that prevailing wage rate is going to be a dollar amount. What is that dollar amount made up of? It's going to be a combination of the base hourly wage rate and any bona fide fringe benefits. So that's going to be your good stuff like health insurance, pension plans, retirement accounts, dental, vision, life insurance, all of that good stuff. Although it does not include any benefit that the employer is required by another law to provide. So your basic hourly rate and any bona fide fringe benefits that the Department of Labor has found when doing their survey to determine prevailing wage rates is, the prevailing practice to be paid to that classification of worker in that area. So to use the electrician example from an earlier slide, if when the Department of Labor does the survey to determine prevailing wage rates for a particular area and type of construction, as we'll discuss, and they find out that in that particular area, it is the prevailing practice for electricians to get $25 in cash wages and $10 an hour equivalent in fringe benefit contributions. That is what's going to be listed as the prevailing wage rate, a basic hourly rate of $25 and a $10 an hour fringe benefit rate. So your total prevailing wage rate is going to be the combination of the two. It's going to be that total $35. And that rate, as I mentioned, is going to be specific to each classification of labor. And it's going to be specific for each type of construction performed in that geographic area where the construction is performed. So we could go on to the next slide, please. All right. Those prevailing wage rates are listed on wage determinations. So I've mentioned that the Department of Labor does a survey. They'll go and do a survey for the wage rates paid in a specific geographic area. That is usually going to be a county, but it's not always a county. And they're going to look at wages paid for particular types of construction. So to do that, we have the construction types categorized. And there are four main types of construction that we look at and that we publish wage determinations for. And we have them listed there on the slide. Building construction, when we talk about building construction, we're talking about the construction, alteration, or repair of sheltered enclosures with walk-in access for the purpose of housing persons, machinery, equipment, or supplies. So these are all your commercial buildings. It's everything from, from a parking garage all the way up to an arena, all kinds of buildings. It also includes the associated installation of utilities, equipment, the incidental graving and paving. So all of the site prep you need to do to get the site ready to build the building, to hook it up to utility mains and so on. The residential category of construction is just like its name sounds. It's the construction, alteration, or repair of single-family homes, townhomes, and multifamily apartment buildings, as long as the multifamily apartment buildings are 4 stories or less. Multifamily apartment buildings above 4 stories are within the building category. Highway construction is another one that is somewhat like its name sounds. It's the construction, alteration, or repair of highways and other roads and streets, but also any project is primarily paving work, like parking areas, runways, trails, and paths, and so on. And then finally, last but definitely not least, you have the category of heavy construction. Heavy construction is everything else. If it is not building, residential, or highway, it is going to be in that heavy category. So the heavy category of construction does include projects such as solar facilities, wind turbines, a lot of utility projects, bridges, dams, dredging, and so on. More information about each of these 4 types of construction can be found in All Agency Memorandum 130 with a lot of examples. That All Agency Memorandum is available on sam.gov, which Megan will be showing to you shortly. Generally speaking, once you have your wage determination and you've verified, yes, this is the wage determination for my locality and for my type of construction, in most cases, majority of cases, that is going to be just one wage determination that applies to the construction of the facility. But we do want to flag a couple of instances where it is possible for more than one wage determination to apply to the construction of a facility. On occasion, if the construction, alteration, or repair of the facility actually takes place in more than one locality, and this is probably more common for big projects, but if construction is going on in more than one geographic area, it's going on across county lines perhaps, then the applicable wage determination for each locality in which construction will take place will apply to that construction of that facility, and the taxpayer, contractor, subcontractor will apply the wage determination for the locality to any work done in each locality. In addition, if the construction of a facility primarily involves just one type of construction, but it also requires a substantial amount of work in another category of construction, then the applicable wage determination for each category of construction will apply to the facility. And again, each wage determination will apply to the work in that category. Generally speaking, when we're talking about a substantial amount of work in another category, we're talking about work that exceeds either 20% of total project costs or $2.5 million. There is additional guidance about that in All Agency Memoranda 131 and 236, again available on sam.gov. All right, so once we have all the prevailing wage rates established, hopefully, you find them in wage determinations, like I said. Where do you get those wage determinations? We do publish, the Wage and Hour Division does publish those wage determinations. We publish them after the survey, and then we publish modifications to update them from time to time. And those wage determinations are all available on www.sam.gov. And Megan is going to walk us through how you navigate sam.gov to make sure that you have the wage determination that you need. Megan?
Thank you, Natalie. Megan Vesper, and I'm a senior advisor with the Division of Wage Determinations with the Wage and Hour Division of the U.S. Department of Labor. Like Natalie mentioned, I'm going to walk you through some step-by-step instructions on how to find sam.gov. Now, here on the screen, you're going to see a screenshot of the site for sam.gov looks like. Once you're at sam.gov, there's a few pieces of information that are to ensuring the taxpayer has the correct wage determination. So we're going to walk through slide by slide and step by step so that you know what that process looks like. So on the screen here, you see the part that you'll get to when you go to sam.gov. On the left of the screen in that red box is the word wage determinations. You'll first click to get to the wage determinations. After clicking on that, you're going to be brought to this web page. Now, there are two categories of wage determinations, one for construction and one for services. Construction wage determinations are the ones you'll want to use in projects, and they're found by selecting the public building or work section. Again, on the screen, that's outlined in a red box. After you click on that, you'll be to this page where you're going to be entering your filtering criteria. By entering filtering criteria, you'll be able to find the specific wage determination that would apply to the facility or project where workers will be paid prevailing wage rates. Now, as you enter the filtering criteria, wage determinations that fit that criteria will populate on the page. Entering the criteria in all fields will help you find the most current wage determination for the facility or project. Now, on the left of your screen, you're going to see 3 arrows that are pointing to where that filtering criteria is. That first one, it might be difficult to see on the screen, but that's where you would enter the state. So the first thing you enter is the state where the project or facility is located. After that, you will enter in the county or independent city. Down menus, so you can either click the little downward arrow to pull up the drop in state, county, whatever the case may be, and it'll filter down to results based on what you're entering. So after you select the state, you select the county, then you'll enter the construction type. One mention on both the county and the construction type is you can only enter one at a time. So in the cases, Natalie, just if you do have a project that's larger and crosses county lines, substantial amount of work in a secondary construction, you might have to come back to this section a couple different times to pull all the determinations you need. But the advantage to SAM.gov is as you're entering the filtering criteria, immediately on the screen, so you'll be able to see it. So after you get the state entered, the county or independent city, and construction type entered, any wage determination that fits that criteria will show up on screen. And this is an example of what that looks like. So in this case, there's one wage that met the filtering criteria that was determination. You're going to click on the wage determination number that's pointed to by that arrow on your screen, and it'll populate the wage determination. Now, on this one count, additionally, wage determinations are published and due. So results show up. Just take a moment to look
at
Megan,
everything. I'm sorry to jump in, but we're having a little bit of audio issues.
Oh,
and
okay.
I think we're gonna pass it over to Natalie. But in the meantime, if you can mute and unmute your audio, that might solve the problem. But apologies for the technical difficulties and passing it over to Natalie while we try to sort that out.
Thank you for alerting me, John.
All right, so thank you. And apologies for the technical difficulty. I'm not sure quite how much everyone was able to hear from this slide, so with apologies, I will just start from this slide, I guess, or maybe just go through. Okay, so you've gone to SAM.gov and you've selected wage determinations, and you're always going to pick public buildings or works, as Megan said. And you'll pick your state and your county and your construction type, and then you will click on the the wage determination that is listed there. That should be the current active version of the wage determination that is applicable for that that locality and that type of construction. And you can click on it and you pull it up. And then if you go to the next slide, we'll show you what that looks like when it comes up. All right, this is going to be one example of what a wage determination cover sheet might look like for a wage determination. And as you can see, there's a lot of information on these wage determinations. So on this cover sheet, as you can see on the slide, you've got the wage decision number and you've got the publication date. So right up at the top is the number and the publication date of that particular modification of that wage determination, so that you can make sure that you've got your most recent one. It also has the state, the construction type, Frequently, there will be a little bit more of a description of the construction type that you can read to make sure that it matches the type of facility that you are looking for a wage determination for. And then you have the county. Again, generally it's the county. Occasionally it will be an independent city. Occasionally it'll be more than one county. And you also have the record of the modifications. And when we talk about modifications, those are just the different times, the different dates on which we published an update to a wage determination. So you can see that there have been 8 modifications to the wage determination, and the most recent one is June 17th, 2022 for this example. And then you can see from the very top of your cover sheet that that is the modification you're looking at, so you know you have the most recent one. After the cover sheet, you'll find the list of labor classifications. Each wage determination is going to contain a different set of classifications and the corresponding wage rates. So those are going to be the classifications and wage rates that were found to prevail based on the data that the Department of Labor received in the survey process. Not all wage determinations contain the same labor classifications, and even when they do, the rates for those labor classifications are not necessarily going to be the same for different localities and different types of construction. So it's really important to review the wage determination, make sure that it's for the locality where your facility is located, that it's for the correct type of construction that your facility falls under. Again, make sure it's current. And then take a look to make sure that it has all the classifications that you need, and in a couple of minutes, we'll talk about the steps to take if it does not. So again, can't emphasize enough that how important that is to go back to my earlier example of an electrician. You can imagine, that an electrician in, Seattle, Washington might not get paid the same as an electrician in Bardstown, Kentucky, just to use an example of a place where I'm from. Similarly, an electrician who is, installing wiring in a single family home might not get paid the same as an electrician who is doing, electrical work on a heavy project. So very important to verify your wage determination. And then as we briefly discussed earlier, and we'll talk about a little bit more again, those classifications are going to have, in listing the rates, they're going to have a basic hourly wage rate, and frequently, but not always, also a fringe benefit rate listed. That prevailing wage rate is, again, going to be the combination of the two. That total sum is what will be due. Megan, oh, you already did. Thank you so much. If you need assistance finding an applicable wage determination, a little bit of additional help navigating SAM.gov, please consult the Wage and Hour Division's Guide to Finding Your Wage Determination, which can be found at our Inflation Reduction Act landing page under Other Resources. And that address is on the slide, and I believe also in the Q&A panel. Slide, please. All right, so in addition to making sure that you have the right locality and the correct category or type of construction, we did mention that those wage determinations update. And it is important to make sure that you have the most recent modification of your wage determination. So when a taxpayer is contracting the construction work out, they're contracting with a prime contractor to perform the construction alteration or repair. The taxpayer needs to use the most up-to-date version of the applicable wage determination that is published at the time it enters into the contract with the prime contractor. That wage determination will then also be applicable for all the prime contractor's contracts with its subcontractors. If the taxpayer is self-performing the construction alteration or repair, taxpayer's like, I don't need contractors, I'm going to do all this work myself, then the taxpayer needs to use the most up-to-date wage determination that's published at the time they start the construction work. Next slide, please. Thank you. All right, labor classifications. Those labor classifications, like we talked about earlier, are based generally on trades or occupations. So we're going to be talking about an electrician, a particular kind of equipment operator, a truck driver. So it is going to be the classifications, not individual tasks listed on wage determination, because a classification frequently perform more than one kind of task within their scope of their classification. It is therefore vital to understand both the scope of the construction project, the construction and alteration and repair of your facility, and what is included within the labor classifications necessary for the work to be performed on the facility, and what work is included in the labor classifications listed on your wage determination, according to local area practice. Again, we do keep mentioning the locality, but that is because it is a very important concept. You know, the work that is performed by, let us say, a carpenter in one locality may be performed more frequently by a different classification in another category, in another locality. So it is very important to know your local area practice, and please feel free to reach out to us if you need assistance with that. In very limited circumstances, if there is not an appropriate labor classification on the general wage determination, the wage and hour division will add a classification of labor and mechanic and a wage rate to the wage determination that is good for that project only. But certain criteria do have to be met, which we will discuss on another slide. So if we can go on to the next slide, let's talk about some examples. So when you're trying to think about what classifications you might need for the construction of a solar farm facility, for example, the taxpayer who's constructing a solar farm facility or altering or repairing the facility will typically need to identify the heavy construction wage determination for the locality in which the facility is being constructed. They're going to make sure they're going to have the most recent heavy wage determination. And the labor classifications for the trades or occupations are based on using the tasks and tools and materials. They're going to look at those classifications. So solar installation, right, that's actually a type of project. That's not a type of worker. So the labor classifications that are typically needed to perform construction of a solar farm could include, not limited to, this is not an all-inclusive list, but could include laborers, electricians, equipment operators, ironworkers, truck drivers, and probably a few other classifications. So the taxpayer or contractor needs to carefully review the applicable wage determination. And if you have any questions about the scope of a classification and whether certain work falls into that classification, again, please feel free to reach out to us. Next slide. Similarly, for the construction of a wind turbine, again, that's typically going to be your heavy construction wage determination. So you're going to make sure that you have the most up-to-date heavy wage determination for that locality where the wind turbine facility is being built or repaired or altered. And consider all the classifications that may be needed to construct that wind turbine facility. So again, you're going to have laborers, electricians, equipment operators, iron workers, carpenters, truck drivers, maybe. All the various classifications, you're going to sit down and think about what's needed and compare that with the wage determination that applies to your project, and direct any questions to us. Once you've conducted that review and maybe reached out to us if you do have those questions, if there really is no labor classification or combination of labor classifications, right, that perform the work that needs to be done for your facility, that's when you're going to reach out to the wage and hour division to see about adding that new classification and wage rate for the purposes of your project. So the taxpayer and the contractor and subcontractor, maybe should have discussions about the scope of work and what classifications are going to be needed. If that comparison indicates that the anticipated work is not performed by any of those classifications, then the taxpayer is going to request the additional classification from us, from the Wage and Hour Division, by emailing ira@prevailingwage@dol.gov. And it's very important that the request should contain all the relevant information that Wage and Hour will need to figure out, first to confirm that no classification on the wage determination does perform that work, and then confirm what the prevailing wage rate for that classification should be. So it's really important that the request identifies what type of facility is under construction, where that facility is located or is going to be located if it's not built yet, what labor classification they're proposing, and what the job description and duties for that classification are. It's really not possible to determine whether a new classification needs to be added just based on job title, because job titles can really vary in their duties. And then propose a prevailing wage rate and an explanation of why you think the proposed classification is needed and why you think the wage rate is the correct wage rate. When the Wage and Hour Division gets this request, we're going to review it and we're going to confirm that the applicable wage determination really doesn't have a classification that performs that work. We also need to verify that the classification that the taxpayer is requesting is a classification that is actually used in that area by the construction industry, right? This is the classification that typically performs this work in this area. And then they're going to review the proposed wage rate for the new classification to verify that it bears a reasonable relationship to other wage rates in that same wage determination, specifically from the same kinds of classifications in the proposed wage determination. So again, very important to provide us with all the necessary information so that we know that we're looking at the right wage determination when we compare those proposed rates. After review, the Wage and Hour Division is going to notify the taxpayer as to labor classifications and wage rates to be used. And once they've done so, that classification and rate can be used for any work performed in that classification on that project. Please do not take that and use that rate on a different project because, again, the other project, the wage rates might have updated since, it might be in a different locality. There are a lot of factors in play. So please keep that new rate just for that project. Next slide, please. All right, you got your wage determination. Hopefully it had every rate you needed, but in the unlikely circumstance it didn't. You had your rates added. You know what rates you have to pay. How do you then actually pay those rates to workers? We mentioned earlier that the prevailing wage rate is a combination of that listed base hourly wage rate and the fringe benefit amount, if any, listed for a classification. It's that combined total. That means that a taxpayer or their contractor, some contractor, can actually meet that prevailing wage requirement in more than one way. So even if the wage determination lists a base hourly wage rate and a fringe benefit amount, it's completely okay if the taxpayer or contractor pays the labor mechanic that combined total applicable prevailing wage entirely as cash wages, or they can pay a combination of cash wages, an employer provided bona fide fringe benefits, so the contributions or costs for the employer providing the health insurance, the retirement, and so on. And that combination of cash wages and employer provided fringe benefits does not have to break down in the exact same way that it's listed on the wage determination. So that can be a little bit easier with an actual math example, although we're going to use a very simple rates to walk through it. So say that you had a wage determination classification, and for that classification, it listed a base hourly rate of $14 plus a $1 an hour fringe benefit rate. That means that your total prevailing wage for that classification is $15. So the taxpayer or contractor has a choice. They can pay $15 an hour cash wages flat out. They can pay it just like the wage determination says and do a $14 an hour cash wage plus a dollar per hour in contributions or costs for bona fide fringe benefits like health insurance. Or if they want to, they can pay a lower cash wage. They could pay $13 an hour in cash wages plus $2 an hour of fringe benefit contributions to get to that $15 an hour. It is really up to the taxpayer or contractor, subcontractor, how they want to break that down. What the important thing is at the end of the day is that those laborers and mechanics did get that total prevailing wage amount. Slide, please. All right, we talked about records earlier, and we did mention that the IRS code does require that sufficient records be kept, excuse me, to establish the amount of the tax benefit. So we're talking about permanent books of accounts and records. It mentions that are sufficient to establish the gross income deductions, credits, or other matters shown. So what does that mean in this context? We talked about how the records are going to need to show that the workers were paid prevailing wages. So the taxpayer and their contractors or subcontractors are going to need to keep records to show what the applicable wage determinations were. If they did have to request any additional classifications and rates from the Department of Labor, they need to keep a record that they made that request and it was approved, right? They could keep records that identify all the laborers and mechanics who perform construction work on the facility. To be able to show that you paid all the labor and mechanics the prevailing wage rates, you got to be able to show who they were, right? And those records would generally reflect the correct classifications of work those laborers and mechanics performed, how many hours they worked in each classification, and what prevailing wage rates they were paid for that work, including any bona fide fringe benefit contributions or costs. So that does mean if part of the prevailing wage requirement is being met by those fringe benefit contributions, those records are going to need kept along with any payroll records for cash wages. We've provided a lot of information. We have some links here that can help provide additional resources after this presentation. So we have our general Department of Labor Inflation Reduction Act landing page. We also have a specific landing page for the Wage and Hour Division that has frequently asked questions. It does the walkthrough on the wage determinations with step-by-step directions. It links you to sam.gov and lets you know that email address I mentioned earlier for doing prevailing wage requests for missing classifications is also available on that site. All right, now that we've taken you through prevailing wages, I'm going to turn it over to Manny to talk to you about apprenticeship. Manny, take it away.
Thank you so much. Appreciate it. Hopefully you all are excited. So now we'll transition to the apprenticeship component here. And so I'll start with that and then I'll turn it over to my colleague, Andy. So on this page here, so in basic terms, the IRA's apprenticeship requirements for certain increased tax benefits has a labor hour requirement, ratio requirement, and participation requirement. It also has a good faith exception as well. For the labor hour requirement, at least really an applicable percentage of the total labor hours for construction, alteration, or repair work on a qualified facility project or a property or equipment, including such work performed by any contractor or subcontractor that must be performed by a qualified apprentice. For the ratio requirement, the above requirement is subject to any applicable requirement for apprentice to journey worker ratios of the Department of Labor or the state apprenticeship agency. And then the participation requirement, each taxpayer, contractor, or subcontractor who employs 4 or more individuals to perform construction, alteration, or repair with respect to the construction of a qualified facility must employ 1 or more qualified apprentice. Now, there's also a good faith exception, which I'll talk about in a little bit. The IRA's prevailing wage and apprenticeship provisions, they apply to the alternative fuel refueling property credit, the production tax credits, the credit for carbon dioxide sequestration, credit for production or clean hydrogen, the clean fuel production credit, investment tax credit, advanced energy project credit, and then the energy efficient commercial buildings deduction. So for facilities that begin construction before 2023, the applicable percentage is 10%. Then it rises to 12.5% for facilities beginning construction in 2023, and then 15% for facilities that begin construction after 2023. Next slide. So now I'll mention some key features of the guidance. So there's reference to statutory definitions of qualified apprentice and registered apprenticeship program. There's key definition of key terms, including employee, journey worker, apprentice to journey worker, construction, alteration, or repair, and state apprenticeship agency. Additional information on good faith effort exception as well. So a taxpayer will be considered to have made the good faith effort and requesting qualified apprentices if the taxpayer requests qualified apprentices from a registered apprenticeship program in accordance with the usual and customary business practices for registered apprenticeship programs in a particular industry. There's also a component of a record keeping requirement and examples of how to comply. On the next slide, I'll speak a little bit about the good faith exception. So the good faith exception here, a taxpayer is really deemed to have satisfied the apprenticeship requirements with respect to a qualified facility if the taxpayer has requested qualified apprentices from a registered apprenticeship program. And a few components. Such request has been denied, provided that such denial is not the result of a refusal by the taxpayer or any contractors or subcontractors engaged in the performance of construction, alteration, or repair work with respect to such qualified facility to comply with the established standards and requirements of the registered apprenticeship program. Or the registered apprenticeship program fails to respond to such requests within 5 business days after the date on which such registered apprenticeship program receives such requests. Additionally, the taxpayers intending to rely on the good faith exception would need to keep records reflecting those good faith efforts, such as documents showing the request for apprentice and the response, if any, from the registered apprenticeship program. The next slide here, I'll jump a little bit and talk about the record keeping. So as further explained in IRS Notice 2022-61, taxpayers must really keep the records necessary to show, among other things, the amount of any credit or deduction claimed. So, for example, the taxpayer would need to keep records showing that the apprentice to journey worker ratio of the registered apprenticeship program on each day that an apprentice was working was met. The apprentice labor hours for construction, alteration, or repair were met, and the apprentice participation requirements were also met. Now, on the next slide, I'll emphasize this before turning it over to my colleague Andy Ridgway, but both the Office of Apprenticeship, OA, that's the reference, and the State Apprenticeship Agency, SAA, they really have a significant role to play in supporting these organizations with technical assistance on joining, developing, or starting a registered apprenticeship program in a clean and renewable energy sector. So OA and SAA's, Office of Apprenticeship and the State Apprenticeship Agencies, they're really uniquely positioned as key resources for assisting new employers to join existing group programs or starting their own programs, assisting and providing referrals to existing programs, and answering questions about registered apprenticeships. Now I'll turn it over to, in the next slide, I'll turn it over to my colleague, Andy Ridgway, who will share a bit about apprenticeship and the IRA resources for businesses and taxpayers and stakeholders. Turning it over to you, Andy.
Thanks, Manny. And good afternoon, everyone. Really appreciate to be joined here with everyone on this webinar and all of you in attendance today on these important provisions. Now that we've talked a little bit about the IRA's apprenticeship provisions, we know that some of you are likely very experienced with how registered apprenticeship works. But we also realize that, the IRA may be bringing additional interests and additional employers and stakeholders into registered apprenticeship. And so we wanted to take some time to talk about some of the basics of registered apprenticeship for you, including the value and business case for it, an overview of the national apprenticeship system itself, and how you could join or develop registered apprenticeship programs. A quick overview of our regulatory framework, both from a quality and equal employment opportunity lens, some tools and resources the Office of Apprenticeship has available, and a place for you to go if you have follow-up questions. So next slide. Great. So what is registered apprenticeship and why do we do it? So registered apprenticeship is first and foremost really important to know. It's not a government program. It is an industry-led program that meets federal and state criteria to ensure that programs are of a high quality nature. They provide pathways for apprentices to work in skilled occupations, including commitments to diversity, quality, and safety. The occupations that are approved for apprenticeship have been vetted and approved by industry leaders. There's an earn and learn dynamic to it, which means that apprentices are employed from day one, where the workers obtain progressive wages as they advance through the curriculum and through their work experience. All registered apprenticeship programs include some form of either classroom or technical instruction related to the occupation that they're being trained on, and they result in a portable or nationally recognized credential or credentials for apprentices, which can include relevant licensing, academic credit, and then certainly when they complete a apprenticeship program, they would receive a completion certificate, which has been recognized as a high quality post-secondary credential. And they help employers tap into and develop a pipeline of skilled trainees and employees. So next slide. So some of the benefits for employers. So as we mentioned, registered apprenticeships are industry and employer-led programs that meet federal criteria for registration. But let's talk about some of the benefits for employers to registering their programs or working with and joining registered apprenticeship programs that exist to meet the EEO and quality criteria. Certainly, one of the benefits that's not on here is the access to the IRA tax credits, but I'm sure you all are aware of that, which is why you're here. But there are some really tangible other benefits that I'd like to go over as well. As we said, the registered apprenticeship model brings together quality criteria on occupations and industry based on their feedback, and has been shown to show some real business advantages, including, it's a proven model for building and retaining a skilled workforce that can support long-term employment goals, increases staff loyalty and retention, including enhanced credentialing to workers, supports the development of a diverse workforce reflective of the communities that they operate in, and is adaptable to the unique needs of a company. Some other findings have shown that it helps reduce liability costs across industries. By having a government validated training model, it has been shown that you can reduce your liability and your exposure in certain areas. And it does also provide access to federal and state resources. Obviously, the Inflation Reduction Act tax credits are a big one. The Davis-Bacon Act for highway projects, potentially grant resources under the Workforce Innovation and Opportunity Act, as well as other state and other grant opportunities. So next slide, please. So talked a bit about the benefits for employers in being part of the registered apprenticeship system. There's additional benefits as well. As Manny mentioned, there are no charge technical assistance resources available to employers and programs from both federal and state staff in outlining and developing programs. Staff are really experts in program design and have a strong track record of assisting labor organizations, companies, employers, and other stakeholders like intermediaries in identifying and fleshing out successful training models using registered apprenticeship. By registering your program, in addition to these credits, I mentioned the prevailing wage provisions of the Davis-Bacon Act, federal and state grants, and they really also can access supports for your workers too. They can potentially help defray some of the extraordinary costs of training or classroom training associated with registered apprenticeship. As well, there may be supports to individual workers for whether it's supplies or other costs, or even just travel assistance or supportive services to enable them to participate and work in an apprenticeship program. In addition to the IRA tax credits as well, some states do have their own state tax credits that reflect apprenticeship utilization. So the registration process has really been identified as a quality signal in the marketplace and can build out recognition for credentialing occupations as well, which can help attract new talent, identify pathways, and ensure alignment with appropriate licensing requirements as well. Next slide. So I talked a little bit about the benefits of registering, and just wanted to talk a little bit about the current registered apprenticeship system here, and this map really kind of helps visualize that. It really is a partnership between the federal government and state governments. In some instances, the Department of Labor has dedicated staff on the ground who are responsible for providing technical assistance and registering programs. And those states are colored in the lighter blue. Those are called OA states, where we have federal staff on the ground that help assist with registering programs. So in addition to the Office of Apprenticeship States, the office has approved state apprenticeship agencies and provided them with the authority to register programs in the registered apprenticeship system. So while in some states there may be federal staff assisting you, and in others there may be state staff, the goal is that there's the same support and high quality programs are registered. And the bottom line is there are registered apprenticeship resources and staff in every state that can assist you with questions about apprenticeship. Next slide. So I talked earlier about some of the benefits of and criteria of registered apprenticeship, but I did want to briefly go over some of the regulatory pieces that go into a set of standards for apprenticeship. So we have two main regulations that address quality labor standards and equal employment opportunity directly for apprenticeship. So I'll briefly go over this. On the labor standards side, there are requirements relating to on-the-job and off-the-job learning. There are criteria for what occupations can be deemed apprenticeable, as we call it. There's a process for industry and employer engagement in that process. There is a requirement where apprentices do receive progressive wages commensurate with their skill attainment. There's safety requirements. We talked briefly about ratios. One of the key parts of ratios is that there's a safe environment for apprentices to be working in potentially high hazardous jobs where there's an adequate amount of supervision with experienced workers, or journey workers as we call them in our regulations, with apprentices. So there are those criteria as well. We do have regulations related to national credentials. And then we do have processes for recognizing state apprenticeship agencies, and then we do oversight of programs through what we call provisional and quality reviews or apprenticeship program reviews. And then I'll take just a quick minute to also lift up our equal employment opportunity regulations. Just real quick, these are dedicated regulations that go above and beyond, just operating in the workplace, that apply to all employment opportunities. Really, with registered apprenticeship, it is an affirmative and intentional commitment to developing a diverse workforce and a diverse workplace. And so we do take that very seriously at the department. And our general view is that programs over time should reflect the communities that they operate in. And so we do have a series of regulations regarding protected bases, whether it's race, sex, ethnicity, gender, as well as some others, national origin, religion, so on. We also have intentional provisions around anti-discrimination and harassment-free programs, including ensuring that apprentices are trained in that. And then for programs that are larger, we do require some affirmative goal setting around targeting diverse communities regarding the community that you're in. And then a few other protections for individuals with disabilities. And then we do conduct compliance reviews over those programs to ensure that they are continuing to meet those very, very lofty requirements. Next slide, please. Okay, so throwing a lot at you about the different pieces and requirements. So you may be wondering, where do I go from here? Andy said a lot, but where do I actually go? I just wanted to lift up, we do have a lot of online tools that help you get started. And then, as I said, at the end of the day, there are staff in each state that can kind of take it from there as you have more dedicated questions. But I did want to briefly go over a couple of the tools that we have on apprenticeship.gov. And I know there'll be links to these these pages, and you can get to them from there separately. But we do have a partner finder tool, which is a way where you can search registered apprenticeship programs in your community, particularly if you're an employer looking to join an existing registered apprenticeship program. We call those group programs, and there's a good opportunity and resource in there to help you find programs that are already operating in your community that you might be able to join up with if you're an employer that has not yet committed to registered apprenticeship. In addition, you yourself could develop your own registered apprenticeship program too, and we do have tools and resources available for that, whether it's through our standards builder tool or we have an express interest link where you can kind of get started down the pathway of talking to dedicated staff that can help you with registered apprenticeship. We do have a tool related to finding apprenticeable occupations, and you can even filter by the construction industry as well there to see what are some of the occupations that you can do apprenticeship with, particularly as you then need to interact with the prevailing wage team and those requirements. And then lastly, but certainly not least, as I said, we have staff in every state. There are links to finding those contacts and getting in touch with them, whether it's a state apprenticeship agency state or an office of apprenticeship state. So I just wanted to lift those up, and I know that those can all be helpful for you as you get started. So next slide. So I believe this is my last slide before we transition to the frequently asked questions. We do have a dedicated page on apprenticeship.gov where you can access a lot of these resources. And I know we'll also be providing resources to the department's overall landing page for the IRA. We also do have a inbox dedicated for questions, apprenticeship IRA at dol.gov. So definitely encourage you to follow up, and I know folks are putting questions in the chat, and we look forward to getting to those as well. But we'll continue to update these pages and resources as we have more information to share. So with that, I think I'll pass it over to my colleague, John.
Thanks, Andy, and thanks, Andy, Manny, Natalie, and Megan for those presentations and valuable information. Before we go through some questions and answers, I do want to remind viewers we've gotten a lot of questions in the chat. A couple things: if we don't get to your question today, we will be continually updating our FAQs on our website. So we strongly encourage you to check out our website, which we put in the chat. We will be putting in the chat one more time. We currently have dozens of FAQs up, and we will continue to update and add to those as more questions come in. Another housekeeping item I want to touch on, a lot of folks have asked if today's presentation is the same as tomorrow's. The answer is yes. If you have any colleagues or anyone you know who was not able to make it today, please spread the word. We'd love to have them tomorrow, same time at 1 p.m. Tomorrow. And then if you know of others who can't make either today or tomorrow's presentation, we also will have this as a pre-recorded webinar available on our website. So with that, let's run through some frequently asked questions now. And I'm going to start with some of the prevailing wage questions we've received and turn over to start with Natalie for the prevailing wage questions we've received, and then turn over to Andy with the apprenticeship questions. So Natalie, a couple folks have asked, will all the IRA's prevailing wage requirements apply to contractors and subcontractors?
That is a really good question. And yes, under the prevailing wage provisions of the IRA, the laborers and mechanics that work either for the taxpayer or the contractors or subcontractors all have to be paid those prevailing wages when performing construction, alteration, or repair on the qualifying facility. Otherwise, to get that enhanced tax benefit.
Great, thanks, Natalie. And does the Inflation Reduction Act have any impact on state prevailing wage requirements?
That is also a question that we see a fair bit, both in terms of Inflation Reduction Act and Davis-Bacon, actually. So in order to comply with the tax benefit requirements of the Inflation Reduction Act, the taxpayer need only ensure that the laborers and mechanics performing that construction, alteration, or repair on the facility are paid at least that federal prevailing wage rate that we've been discussing. But as we discussed, that is your basement rate, right? That's your minimum. There may be other wage and hour requirements that apply to that, to the taxpayer or the contractor or subcontractors, and those will still continue to be applicable. The Inflation Reduction Act prevailing wage provisions do not make those other requirements go away. So that could include other federal labor laws like the Fair Labor Standards Act, or it could include state or local laws, including state prevailing wage laws. Those may also apply. And those laws will impose separate legal requirements from the Inflation Reduction Act that may require higher wage rates to be paid.
Great. Thanks, Natalie. And we have another question that came in asking, do taxpayers also have to comply with the President's executive order on project labor agreements to receive enhanced tax benefits under the Inflation Reduction Act?
Oh, that is an important point. Although contractors are certainly welcome to enter into project labor agreements for the construction of their facility, the Executive Order 14063 generally would not apply to those construction projects that are receiving those Inflation Reduction Act tax benefits, because Executive Order 14063 only applies to certain federal contracts for construction.
Thanks for that clarification. Another question we received reads, under the prevailing wage provisions of the Inflation Reduction Act, how should workers be paid when they work in more than one labor classification?
Oh, and I'm glad that we got this one, because I'm going to flag this as an area that frequently causes people to be paid incorrect prevailing wage rates. So this is an important one. So when workers are working in more than one labor classification, the taxpayer or the contractor, subcontractor, can pay them the different wage rates that apply to each classification if and only if they accurately keep track of the actual hours that the laborers and mechanics work in each of those classifications and pay those different rates in accordance with that really accurate record. What the taxpayer, contractor, or subcontractor may not do is estimate the hours worked in each classification or use an average hours worked in each classification and pay based on an estimate or an average. If they want to pay the different rates as opposed to just paying the highest of all the applicable rates, they do need to keep that accurate record of the time spent in each classification and pay accordingly.
Thanks, Natalie. And last question, an important one about definitions. The Treasury guidance and DOL FAQs refer to definitions of construction, alteration, and repair work. How will companies know whether their activities constitute construction, alteration, or repair? And is there any written guidance that provides additional information about what activities are included within this definition?
Well, the definition of construction, alteration, repair is actually a pretty broad definition. And it includes all types of work done to any covered facility. So that's going to include the alterations and repairs. It's going to include installation of equipment or systems into a facility where appropriate. So that means that the definition is not only covering new construction or, a complete renovation or rehab of an entire facility, but it's also going to include changes or additions to facility structural components or systems, or any alterations done to improve the stability, safety, or functionality of a facility. So to make it more efficient, to make it safer, to make it work better. The definition also includes repairs, as was mentioned. So that in that case, we're talking about any one-time fixes to something, some building or some facility component that no longer works as intended, although it would not include routine and recurring maintenance. Wage and Hour has provided guidance on whether certain types of work should be considered construction. So we have that available in all agency memoranda, which are available on sam.gov. We also have some examples in Chapter 15 of the Wage and Hour Field Operations Handbook, and also in our Prevailing Wage Resource Book, both of which can be found on our website. But of course, if you've looked at the guidance and you still have questions about whether a particular activity falls within that definition, please feel free to refer those to Wage and Hour at any time.
Great. Well, thanks now for those clarifying answers to some of the questions. Andy with ETA for a couple of questions, apprenticeship programs. So Andy, the first one we received from a couple people. How do I know if an occupation needed for work under the IRA is suitable for apprenticeship?
Thanks, John. And yeah, it's a great question. So as I mentioned briefly, registered apprenticeship programs are available in occupations that have been determined by the Office of Apprenticeship as apprenticeable occupations. That may be a new term for some of you, but really means that they've gone through our regulatory criteria and vetting for registered apprenticeship and can be found on our occupation finder. We have approved many occupations for registered apprenticeship programs within the meaning of construction, alteration, or repair work covered by the IRA's increased tax benefits. Using the Occupation Finder tool, you can browse by industry. For example, browsing by construction leads to many results of occupations approved by our office, whether it's, labor, electrician, iron worker, those type of occupations, carpenters. You can also find additional occupations in construction, alteration, and repair for clean energy projects by searching other industries such as manufacturing, transportation and warehousing, and utilities industries.
Great. Well, thanks a lot, Andy. Really appreciate that. The last question we have for today is, what steps do I need to take to register a new apprenticeship program or join an existing one?
Great question. So there's a couple different routes you can go, especially if you're an employer. Employers may sponsor their own registered apprenticeship programs and hire their own qualified apprentices by registering their new programs with the appropriate registration agency. I talked a little bit about before on the map, whether it's an Office of Apprenticeship state or a state apprenticeship agency state, determining whether to register with the Office of Apprenticeship or an SAA depends on where you're located, and then register and operate their program. As mentioned earlier, OA has many resources available for potential sponsors on apprenticeship.gov, including assistance in locating and contacting your appropriate registration agency, information about registering a new apprenticeship program, and then assistance in actually developing registered apprenticeship standards, as we call them, using our standards builder tool. Additionally, employers may be seeking to join registered apprenticeship programs that are already in existence for the purpose of hiring qualified apprentices, and may do so by first identifying group registered apprenticeship programs and their needed occupations and geographic area. One tool that just let me talk a little bit about group registered apprenticeship programs. They are programs in which multiple employers participate in employing apprentices from the same apprenticeship program. And in those instances, they can request an apprentice from the program. The employer agrees to abide by the standards of apprenticeship and the requirements of the registered apprenticeship program. This is customarily done through an apprenticeship agreement. We sometimes will call it an employer acceptance agreement, or you could be a signatory to a registered apprenticeship program's collective bargaining agreement or project labor agreement. Once an employer has joined a registered apprenticeship program, the employer may request apprentices through that program's usual process. I mentioned a little bit earlier, the Office of Apprenticeship has a partner finder tool, which will allow employers to search for programs, including group programs, by occupations and state. I will flag, state apprenticeship agencies may have additional resources for identifying programs as well, so you can always reach out to them through the links that we have as well. And lastly, just wanted to put a plug in. We have developed and staffed a dedicated email inbox to receive questions related to these apprenticeship-related provisions of the IRA. So feel free to email us at apprenticeshipira@dol.gov. And we look forward to continuing the conversation, because I know there will continue to be questions going forward. But back to you, John.
Thanks a lot, Andy and Natalie, for answering some of those questions. Unfortunately, that is all the time we have for today. But as I said earlier, we are continually updating our FAQs on our website, and we really encourage you to continue taking a look and checking out the resources that we have. For some of the information that Andy just referenced and the information that was included in both Andy, Manny, Natalie, and Megan's presentations, you can visit our website at dol.gov/general/Inflation Reduction Act tax credit, which is listed on the screen right here, to find more resources on the information shared today. And again, answers to many of your questions. So I wanted to just say thank you for attending this webinar. We hope you found the information that we presented helpful and informative. At the Department of Labor, we're really excited by these tax credits, and we know that prevailing wages and apprenticeship programs create better outcomes for both employers and workers. We strongly encourage you to take advantage of these tax incentives, not only to aid our clean energy transition, but to create good, equitable jobs and a skilled workforce while doing so. On behalf of the Wage and Hour Division, the Employment and Training Administration, and the Department of Labor, thank you again for attending this session, and we wish you all a happy and healthy holiday season.